The next case set for argument this morning is Yousef versus, is it Iskander? Iskander?
Yeah.
Okay. This is case number 30216. Counsel is present for each party, so each of you will have 15 minutes to present your argument to the court. The appellant may reserve up to 5 minutes for rebuttal. Attorney Hoover, just let me know how much time you want to reserve when you get started, and I'll let you know. Also, of course, we have it on the TV screen there. The arguments are recorded, as you both know, so we ask that you stay at the podium, keep your voice up. We ask that you not use the names of children or minors or victims, and refer to them by initials or child, etc. Court has read the briefs, and we are prepared to proceed when you are. So how much time, if any, would you like for rebuttal?
5 minutes, Your Honor.
5 minutes. Good morning. You may proceed.
Good morning. May it please the court. We are here today on the second appeal from the same case, resulting in an issue of a significant student loan debt to husband. During the course of the marriage, husband and wife immigrated from Egypt together, both of them coming to America with husband with a cardiology background, wife with a pharmacy background, and both of them had to be re-credentialed here in the United States. Wife did that immediately as a pharmacist, with husband supporting her. Husband then went to medical school. Prior to husband completing medical school, the marital relationship fell apart, resulting in this divorce case. We are alleging essentially two major issues of error in the trial court. One is that the trial court determined that portions of the student loan debt were in fact separate property. The second major issue that we raised with the trial court decision is that it was inequitable based on the factors to allocate all of the marital debt or student loan debt to husband. In the first appeal, this court gave us domestic relations lawyers much guidance in adopting a sister appellate court's definition of marital debt as it applies to the marital and separate property statutes. In doing that, the court here opined that marital debt is considered to be marital if it is for the joint benefit of the parties or for a valid marital purpose. This court further opined that debts are presumed to be marital unless proven to be separate. At the remand from this matter, our position is that while the trial court reanalyzed the factors and restated this court's holding in the determination of marital debt, is that they still did not engage in a determination of whether this marital debt was incurred for the joint benefit of the parties or for a valid marital purpose. Instead, the trial court found that husband accrued essentially $174,000 of debt towards his tuition and allocated that as separate property, without making a determination that it was not for the joint benefit of the parties or not for a valid marital purpose. The other portion of the student loan debt, which is approximately $129,000 from those years in question, the court determined was marital because it did go to living expenses. Our argument is, I don't believe we can have it both ways. The student loan debt was accumulated in bulk. The trial court was provided a joint exhibit from the parties which allocated how it was applied as between tuition and living expenses, but it was still the one bulk accumulation of debt. The testimony established from both parties that when husband began medical school in 2015, those loan proceeds were deposited into their joint account. Wife had access to the joint account. She acknowledged such. They all operated under the assumption that those proceeds were deposited in those joint accounts. However, the court went on to indicate that because wife never saw the loan documents and didn't understand how student loans worked because of being from Egypt, that therefore it was husband's separate property. We believe the court erred in that because if the standard is that the parties have to see the loan documents, there are many, many divorce cases where one party is incurring debt and the other is not looking at a loan document, but the court still presumes those debts to be marital in nature.
Counsel, I have a question for you. I don't want to force you into your equity argument, but I'm kind of heading there. Let's just assume for the sake of this argument that what you're saying is correct and the determination of the tuition portion of the loans should have been marital property, trying to keep these straight. Didn't the court's journal entry kind of do it in the alternative this time around? I mean, but if not marital, here are the reasons why I think equity should attribute it all to husband.
Yes, that's exactly what the trial court did. Our issue with that, Your Honor, is that in examining the factors between the equitability issue is, one of the factors is the relative assets and liabilities of the parties. The court examined husband's potential income somewhere from 11 to 6 years down the road. So husband's in residency at the time of the trial. Everyone stipulates to husband's income. There was a tiered system of every year it went up slightly, but essentially it was between $50,000 to $60,000 for the entirety of his residency, which was deemed to be approximately 3 years, potentially an added year. Wife testified that she did not believe husband would make $300,000 to $350,000, except for 11 years down the road. She thought that would be realized. Husband thought it would be realized in potentially 5 to 6 years. But either way, our argument is at the time of this, husband's making $60,000, and that for the court to examine the relative assets and liabilities, it should have been at the time. I think the court could also certainly examine the long-term assets and liabilities. I think that's a relevant factor, but the court skipped over completely what the relative assets and liabilities of the parties would be to repay this debt, and what income stream would be used to pay that debt for at least, by agreement of the parties, at least 6 years before that would be realized.
So on that, I'm going to circle back to my initial question, and it wasn't really a very good question. I don't want to say, well, then does it even matter if the court was right or wrong on the tuition portion? But for purposes of our analysis, do we even need to make that decision? Do we just jump to the per equitable findings?
Perhaps not. Yes, I would agree with you. I certainly, from a trial lawyer standpoint, we love when you jump to anything because it gives us all direction in the future. But as far as this case is concerned, I do think that potentially that's the least significant argument. The more argument would be the equitability as it's applied to this family. The other issue that we would raise before this court is based on this court's precedent in the Polachek case, which is really the only other student loan case that is on point to our current issue, is that this court opined that marital debt is presumed to be a issue of the marital state absent the issue of financial misconduct or covert financial activity. So that's the other pressing issue that we have, is that if we are saying, okay, marital debt, including student loans, is presumed to be joint, and from the joint efforts of the parties, absent a finding that husband engaged in financial misconduct or covert financial activity, that, again, going to an equitability point as well, is that that should be then equitably divided between the parties. Of course, our position is it was inequitable as the court divided it because they skipped over the relative assets and liabilities of the party. But we do believe that, based on Polachek reasoning, is that Polachek asked trial courts to consider the economic circumstances of the parties at that time and any other relevant factor. And so again, we keep going back to at the time, there's no evidence of financial misconduct, there's no evidence of covert financial activity. Both parties are well under the assumption husband's going to medical school, while wife may have, position maybe I didn't know what the student loan debt was going to be. Husband testified to the same. And husband said, I didn't know either. We signed on the dotted line and interest accrues each day. And so now we've got this huge balloon of student debt to deal with. But at the end of the day, husband didn't make any decision that was not also known to wife. And so if we can't get to financial misconduct or covert activity, then the presumption should be is that this is fully marital and it's equitable to be considered based on the relative assets and liabilities between the parties. We also believe that as this court opined in Polachek was that if the court applies any punitive measures in deciding that that's also a potential error. In Polachek, it was a mention of wife moving her boyfriend and his children into the home and consideration. In our case, The trial court continues to mention that husband filed for divorce mere days before the birth of the third child and served wife without telling her. Certainly, the facts in the record are what they are, but we believe that the court, in examining these factors, especially in light of the student loan debt, indicates the trial court approached it from a punitive measure rather than just a pure equitability based on what the statute requires. Thank you. I would reserve the remainder of my time.
All right, let me just check, any other questions?
I do have a question.
Sure, go ahead.
In terms of the loan or the amount of the loan, I noticed opposing counsel's brief and the court's journal entry made mention of, well, husband didn't give us the information we needed. We don't know whether it was in forbearance, et cetera, et cetera. How do you address that comment from the judge?
That's true. I was not trial counsel. Neither of us were trial counsel. And so, yes, and we, like you, have the record to work with. Wife produced at trial a indication of her living expenses and her income to demonstrate what her expenses were and what her relative, income to debt was. Husband did not do that. There was no mention whatsoever about whether they're in forbearance, what the payment will do, anything of that factor. But our argument is because the court considered wife's monthly budget, because the statute requires relative income and examination between the parties, that if the court considered wife's, the court should have also inquired on their own about husbands.
Counsel, you have one other
Yeah,
question.
just one small question. I believe you said, counsel, you used the phrase, we signed on the dotted line, and I just want to make sure, when you say we, do you mean that both husband and wife signed on those loan documents, or just?
That's a great question. I believe husband was the only signer to that. And I think that was the issue the trial court had, is that wife did not sign the loan documents. My position is that in greater examination of domestic relations law is that that's a factor that the trial court can't take into consideration because it's the presumption of still marital regardless of just one or the other signing.
Thank you.
Yes, thank you.
All right, thank you for those answers. You'll have 4 minutes and 15 seconds for rebuttal. Counsel, you have 15 minutes. Take your time whenever you're ready.
Thank you, Your Honors. May it please the court. Your Honors, this case is, as been discussed in my esteemed colleagues' arguments, it's coming down to some semantics relating to the journal entry from the judge. However, this court can look at the factors that were laid out by the court, looking at Polachek, looking at the economic circumstances of the parties, to determine whether this debt should be allocated to father to husband. And it's my client position that based upon the evidence that was presented at the trial, based upon the economic circumstances of the parties, whether you call it separate debt or marital debt, it should be allocated to husband in this case. If you look at the economic circumstances of the parties, first of all, my client's a pharmacist. She makes $120,000 a year. Husband was in medical school. He was already received his medical degree in Egypt, but he also had to do additional schooling here in the United States to get a job as a physician in the United States. He was in medical school. There was varying testimony throughout the trial where the husband would make anywhere from $300,000 to $600,000 once he became a cardiologist, which was his goal, and he was a cardiologist in Egypt.
Well, counsel, I guess I have a question for you about that.
Yes.
Because you were speaking in the present for wife, $120,000, as though she'll never make a dime more than that. But looking to the future, we have no idea how many years for husband, and I guess when I say you, I'm talking about the journal entry. How does that balance into this in terms of equity?
I think it's looking at the earning potential, earning abilities of the parties. Yeah, husband may have been working as a resident. Everybody knows a resident is at a reduced income. But his earning abilities are so much higher than wife's ability to earn. And that's part of the economic circumstances of the parties. And there was testimony from both parties regarding husband's potential earning abilities. He even testified what he would think he'd be making. Based upon just low estimates, it's 3 times what wife was making. And wife testified that she believed that she was going to be basically at the same income. So I think looking at a student loan situation, I think the court has to look at the potential, because it has to look at the economic circumstances of the parties to pay back that debt. And the judge found in this case that it would be equitable and appropriate for father to take on, the husband to take on this liability, be responsible for this liability, because she believed, the judge believed, based upon her entry, that he would have he would be in the best economic circumstances to pay off that liability. And it's fairly typical.
Excuse me, one
Yes,
question.
yes, Your Honor.
I'm correct that wife was receiving child support at this time? I know that there wasn't any temporary child support, but there's a child support order
Yes. Yes, there is a child support order, Your Honor.
that was based upon what income values of the parties?
It was based upon their income values at the time. It was not based upon any potential income for father or husband. I was not trial counsel, so I don't know why that argument was not made, but that could have been made at the trial, that it would be based upon his potential income.
But arguably, child support could have been modified if his income jumped up to $600,000, correct?
Yes, Your Honor. And at this time, the record, we don't have, I think counsel, I know where we're at in the case, but at this time, the record's just based upon, what his income was at that time. There are pending motions right now in the court on child support. So, Your Honors, as I indicated previously, it would be unfortunate if this case got held up on just semantics. I think that this court can look at the equitable factors of the parties. Looking at wife's expenses, the court found that she was at a deficit, that it would be very difficult for her to make payments on the student loans. Looking at her knowledge of what was going on with the student loans. I mean, at the trial, there's testimony of the husband. The husband said throughout the marriage that this was going to be my responsibility, that this is my money, don't tell me what to do with it. And I think the trial court took that into consideration as one of the circumstances, one of the factors, that husband had indicated that this is going to be his responsibility, and he believed it to be his responsibility. Husband's the party that filed the divorce just prior to finishing medical school. And at the time of the trial, he was in his residency. So, Your Honor, I would ask this court to simply look at the equitable factors that have been laid out by this court, Polachek. And I think Polachek has given the bar and counsel some very good guidance on what the court should look at. The court looked at that information. The trial court's in the best position to weigh the credibility of the witnesses. And the court weighed the credibility of husband and wife, looked at the equitable factors, and made what my client believes is the appropriate determination, what's in the best interest, and what's reasonable and appropriate in this situation. Your Honors, looking at the other issues in the case, spouse support issues, the court weighed the factors. I don't think appellant is arguing that the court did not consider the factors. The appellant believes that because the court said, I guess, negative facts about the appellant during in the journal entry, that somehow that should influence whether or not the spouse support award or the lack of spouse support award was reasonable and appropriate. When looking at the factors, the court determined that spouse support was not appropriate in this case. The court looked at the fact that basically dad is in residency, dad is making anywhere between $50,000 and $60,000 a year. Mom is primarily taking care of these children full-time. Dad provides very little help and assistance with the children. Looking at the budgets of the parties, and the court found that it was not reasonable appropriate at this time to award spouse support. And I think based upon the factors, that was the correct decision. Looking at the child support issue, there's an argument that the court was mandated to consider the deviation factors. That is not laid out in statute, and that is not laid out in the case law that the trial court is mandated to consider any deviation. If they do deviate the child support award, then the trial court would have been required to consider the deviation factors. But in this case, the court determined that the court did not decide to deviate the child support in any manner, and and I think the court could probably look at all the facts and circumstances that are laid out in the trial court in its decision to determine that the deviation was absolutely not appropriate in this case. And as just going back to the student loan argument briefly, as this is one of the questions we're asked, husband didn't even provide to the trial court the payment terms, whether or not when he was going to have to begin making payment on these student loans, and I think that's definitely a factor that the trial court took in consideration, that based upon the information that was presented to the trial court made its best determination on who this debt should be allocated to, and the trial court determined that it should be allocated to the party that incurred the debt, and which has been customary in domestic relations court.
Counsel, I know you weren't trial counsel, but in your review of the record, did husband testify to any of his monthly debts or what his budget was?
Not that I recall that there was any evidence presented regarding his monthly obligations. I know wife had presented her exhibit of debts, but I don't believe that husband had testified to his debts in the record, or to his monthly obligations in the record. And I'm happy to answer any questions that the court may have.
All right, there are no questions, so thank you for your argument, and counsel, you'll have 4 minutes and 15 seconds for rebuttal.
In response to my esteemed counsel's position in looking at husband's earning potential down the road, this court in Palachuk previously held that a financial value of a degree cannot be quantified because the value depends on choice and availability of work, whether the worker is good at what he does, and many other potentials, all of which are unknown at this time. So our position would be, again, just that, is that husband, in residency is known. They sign a contract, they know what they're going to be making from year to year. After that, there is a great number of variables to be taken into consideration with somebody with a medical degree, including what availability is available for various jobs, whether it's in cardiology or not. I believe the range of husband's potential income testified to both parties was between $300,000 to $650,000, and that was dependent on a number of factors, including whether husband would do additional years of training at a reduced salary to ultimately go on to become a cardiologist, potentially making $650,000, or whether he would not. Our position is that those are things that the trial court should have considered, or in looking at this at a bare minimum, if they had considered the long term, they should have also considered the current, what the current relative incomes and assets were, and availability to repay this. The other issue is when we're comparing the relative assets and liabilities of the parties and their expenses and their budget, we've already gone over the fact that wife had an entire exhibit, laying forth what her budget was. One of her considerations that the court made note of in their journal entry was that she was spending $3,000 a month in childcare expenses. However, the court also failed to consider, in looking at that husband was contributing $1,500 a month in his child support obligation, which took wife's childcare expenses into consideration, as childcare expenses are one of the statutory factors for the ultimate child support calculation. And so again, our position is, if you look at mother's budget and income alone, it doesn't give a full picture of what both parties' finances are. And at the bare minimum, if you are considering that wife has these childcare expenses and making note of that, in saying wife does not have any money left over of which to pay the debt, you said wife had this $3,000 a month expense, but you totally discounted out the fact that husband was contributing to that. So again, in looking at the relative assets, liabilities, income source, that should have been a factor taken into consideration. When the court looked at the budgets of the party, they looked at the budget of one party. Yes, the record was devoid of husband's budget. Wife certainly put forth a very itemized exhibit. Husband did not. In response to your question asked of my counsel here, husband, I believe, testified that his expenses were the same as what was set forth in his affidavit of income and expenses, which was filed at the beginning of the case. So although he did not produce an additional exhibit, and I do not believe went into any length in testimony about those expenses, there was still an indication filed on the record in that affidavit of income and expenses filed at the beginning of the case that would have set forth significant expenses that he had as well. However, I would agree, I believe everybody in this room is under the same impression that certainly there was no information about what the loan payments would be, and the record speaks for itself on that issue. In response to wife's testimony that when she was asking husband about the student loans, his position is that he would take care of it. I believe what husband testified to is that he knew that this was the only way they were going to get through medical school, and that after that they would figure it out. I certainly believe husband's testimony would lead everyone to believe that that was under the presumption that the marital relationship was intact. And so not that he's saying, oh, I'm going to be solely responsible for this, but as a marital estate, that they would pay for it from a future income stream. So now that husband alone has the future income stream, certainly of a medical professional, the question is then, is it equitable to allocate all of that debt to him? We would certainly argue it's not.
Counsel, with that, your time is up.
Thank you, Your Honor. Have a great day.
Thank you both for your arguments. We'll take the matter under advisement, issue a decision in due course. The clerk of courts will give each of you a copy on the day it's released, and the opinions are posted on Supreme Court of Ohio's website. Again, on behalf of Judge Callahan and Judge Sutton, I want to thank you